live stream. Quick summary, this is not an official record by any means. This does get deleted immediately upon conclusion of today's proceedings. We are doing this because, oh, I'm getting echo, there you go. I'm doing this because, as you have seen, we have a meeting ID and a password to get into any particular hearing. That blocks public access. And so the temporary fix we've got to allow public access to our hearings is to live stream on YouTube. Not participate, but they can see. Anyone who wants to see what I'm doing. So that's what I'm doing. But if you want to make a record, you still have to have your own court reporter, okay?
Okay.
All right. So this is the defendant's motion to quash service. I've had an opportunity to review the motion. Let me pull it up here. And Mr. Haynes, you represent Midland, is that correct?
Yes, Your Honor.
And I believe, ma'am, did you file any supporting affidavits with the motion, or were you just going to present other evidence today?
I did on March 30th file some exhibits, and I called the clerk this morning.
Oh, there they are. All right. I see there's a tax return that was filed. I don't know if
Correct. A letter as Exhibit A was a letter from my ex-husband dated November 6, 2013.
Okay.
Exhibit B is the contract with the credit, I don't know what that's called, okay. Family credit, which is irrelevant to this proceeding. C is my 2016 W-2, and Exhibit D is my termination letter from February of 2017.
Okay, got it. All right.
I did copy ABC Legal to their service on the same date that it was filed.
All right. Well, I do have the exhibits filed in the court file. So, Mr. Haynes, have you had an opportunity to review these exhibits? Or do you have access to them in the court file?
No, I haven't. When were these filed?
March 30th.
March 30th.
Yep.
Oh, March 30th. Okay.
Yes, sir. This was originally part of the motion to vacate.
Correct.
But considering these are kind of the same issues, I don't see why they couldn't be used for this hearing as well.
Oh, okay. Okay.
All right. All right. So the procedure on a motion to quash, the initial burden goes to the plaintiff to establish a prima facie case that the service was proper. So, Mr. Haynes, I turn it over to you.
Okay. Should I ask Ms. Soto some questions here?
Yes.
Sure. Ms. Soto, would you please raise your right hand? That's right. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. Very well.
Yes.
Thank you, ma'am. All right. Mr. Haynes, go ahead.
Okay. Now, Ms. Soto, I see on your motion here, you state that I guess it was your son. Was your minor? You had a son, is that right?
I do.
Okay.
He was a minor at this time.
At the time.
He was a minor at the time.
6 years ago, right?
In 2016.
Correct.
Right.
Correct.
Okay. How old was he in 2016?
In December of 2016, 16.
He was 16 years old?
Yes.
And he was, now it also states that he lived sporadically with
he doesn't live sporadically. He visited with his dad. We were divorced by 2016. He had visitation, and it was sporadic. My son stayed there sometimes on the weekends, definitely after school. I picked him up after school because we left that address as his school's designation. So regardless of where I was living, he was in the same school, same bus stop, and we made arrangements to pick him up after school, and he'd stay there sometimes on the weekends, barely.
Okay, so he was attending school in at this address.
That area.
3980.
Yes.
Okay, and so after school he would go to this address.
Yes.
And that was every day?
Yes, after school, he would go to that address every day. Well, in 2016, December, no, he still didn't have his car. We bought his car in, I want to say 20. In June of 2016. So no, by June 2016, he didn't go to his dad's after school anymore. He turned 16 and we got him a car in June.
Okay. So where would he go after he left school?
To my house.
Okay. And where were you living at that time?
In June of 2016, I was living with a friend of mine on Immokalee Road, which was, if he went to his dad's, he'd go to the right. If he went to my house, it'd be to the left.
Okay.
So he was right off of.
What about
I was to the left.
16?
Now, I was going to ask now.
Right,
You
what
say
about
he got a car in June 2016.
June of 2016.
Okay. And so he was still attending school in December
Yes.
of 2016
Yes.
in Naples, using
Yes.
this address as his residence.
He was using that address as we were using that address as my son's residence for school designation.
For school
We never
designation.
changed our addresses.
Okay. So, and when you say we, saying you and your husband?
Yes, we never changed the addresses to any other address that I was at because the stability was in that house for my son, for him to have the school, be in the same schools. He was there since elementary, and we wanted him to graduate in that same cluster of schools.
Okay. So there was at least some record of his that being the residence, the family's residence.
For my son. For the school designation purposes, that was my son's address. But my son has always lived with me. I've claimed him every year since he was like 7 years old. And he lived with me. I had full custody. If my ex-husband he was supposed to see him every other weekend. And it ended up being like that year, probably Christmas, vacations, 1 weekend a month. So even if he got to see him every other weekend, it was 50 times that year.
Okay.
Overnight.
Okay. So he never would go back. Now, and he was your son was the one that accepted the substitute service. Is that right?
I think my son says no. That's where I have a discrepancy, because when I got this at where I work now, they served a writ of garnishment. I read the file and I read the clerk's file and I called my son and I asked him, and he swears to me he never received any paperwork. But by December of 2016, my ex-husband had also moved in his girlfriend and her child. So I don't know who accepted service, because my son tells me he didn't, and I don't speak to my ex-husband, but my son called him and he asked him, and my ex-husband says that he didn't receive any paperwork. I trust and believe that if they had received anything for me, they would have given it to me. Okay. So it says my minor son was served. I don't know how they got his information. Maybe they asked, what's your name? But if someone knocks on the door and my son was to answer in December of 2016, and someone says, is your mom home? He would have said, no. Not, does your mom live here? It would have been a different answer.
Yeah, I understand that. I think the service here is by substitute service, with your son accepting that service.
But my son didn't. Well, the thing is that I don't think that that's proper service, because I have a case that says you can only serve.
Hold on. Ma'am, we're not at this point yet.
Oh, sorry.
I will give you an opportunity for argument, but we're not there yet.
Okay.
Okay.
My son didn't live there, and I didn't live there in 2016. I have the letter that is Exhibit D, dated November of 2013.
hold on, ma'am. Like I said, I will give you an opportunity to present your side of this, but right now, actually, it's still the plaintiff's burden to show me
Oh, I'm sorry.
that there's at least, prima facie evidence that this was valid service.
Okay. All right. So yeah, you're telling me that your son was 16 on December, the date
Of 2016.
Yeah, the date in question was December 16th. Here, let me
27.
see. 27. Yeah, December 27th. Your son was 16. And then you also state that your son was at that residence as part of his visitation with his father. And around December 27th, that's around the holidays. And you've already admitted, that he would see him during the holidays. So
that's correct.
It would seem to me it's more than likely that he was there at the residence. The residence is being used as the principal place of abode for some type of purpose, and it's for this particular purpose, school purpose. It seems to me that service seems to be substantially correct.
Well, here's the thing. Ms. Soto put in her motion the definition the courts have created to define usual place of abode. I reviewed the case law surrounding that issue, and she's 100% correct. The usual place of abode is the place that the person is living at that time. It's a very specific definition.
But yes, Your Honor. Now, but the thing is,
using it for one purpose or another, but very specifically, if the person is living there at that time, that is their usual place of abode.
Mm-hmm. Well, from what her testimony is saying, that they were using this address as their place of abode for these school purposes.
Well, let me
for my son.
Right. They were. I'm just sort of be perfectly honest with you. You're not supposed to do that. All right. You're not supposed to tell the school system that you're living there when you're not, just so you can continue to use that address for school purpose. I understand why.
I went to the school and I told them that it was out of designation.
I understand.
Out of school.
Not our issue today. But you're saying you personally, and frankly, it doesn't matter where her son was living at the time, because he's not the defendant in the case. So you're telling me that you personally were not living there at that time?
I had not lived there since 2013.
And could you give me your address in 2016?
In 2016, I don't know the address to the Immokalee Road address. I looked it up. It was with Yolanda Oscar. She was a friend of mine that I had for a long time. And I was in the middle of trying to figure out if I was going to stay in Naples or come to Miami. So that was short-lived. But before that, in 2016, I lived at 4500 St. Croix Lane. From 2013 to 2000.
I didn't quite hear you say from 2013.
40 to 2016.
And what month in
2015. And then I went to live with Yolanda in 2015, 15 and 16.
Okay. And do you have anything to support your residence at this Immokalee address?
I don't have anything. That was very short-lived. I don't have anything to show that I was living in. I was living with Yolanda and I was coming back and forth to Miami. And by August, I have statements from my bank that I was looking through my bank statements. In August of 2016 is the first transactions, which were there are 10 transactions, when I was coming back to Miami to start looking for work here. So August of 2016, by November 16 of 2016, I had a deposit from the W-2 that I provided as Exhibit C, is my first deposit from Hasbin, and Mendoza that was down here.
Okay, so hold on. So Exhibit C, and I'll pull that up so everyone can see it. Which one was Exhibit C? That was
The W-2.
the W-2, and all of your PIA has been redacted, correct? Because I'm gonna screenshot
Yes.
it for everyone else to see. All right, so this is your
Yes.
here we go. So let me just look at this real quick, and then Mr. Haynes, I'll pull it up so you can see it as well. Okay, sir?
Okay, thank you, Adam.
Yes, sir. What's this date? Where's the date of this?
The W-2.
2016. W-2 for 2016. All right. Let me pull this up. Do a screenshot. All right. Can you all see this? So this does indicate, so this is defendant's Exhibit C. And this has Ms. Soto's address as a Homestead, Florida address, at least for some period of December 2016. Some period of 2016, excuse me. So ma'am, when were you at this address?
That's my sister's address. That's my sister's home address. She's lived there 10 years easily.
No, but were you living there?
I was living there. Well, I came 3 times a week to Homestead, and then I was working the rest of the day, sometimes remotely, 2 times a week. And that's when remote work was not popular. That's why that employment didn't last that long, because I was back and forth still. I hadn't found stable employment in Naples the way that I had before I got divorced. And then I was back and forth looking for work, but I knew my son was still in school. I had to be in Homestead. I had to be in Naples. And our plan had always been to move to Naples when my son graduated, to Miami when my son graduated high school. So I was working remotely, and that's why that employment didn't last as long. So I was living with Yolanda, staying with my sister.
Okay. And then when were you divorced from your ex-husband?
2015.
Okay.
Yes, because I left 13, filed 14, divorced 15.
Got it. All right, Mr. Haynes, any further follow-up?
And Ms. Soto, you were stating you were divorced in 2015. So where were you living in 2015?
At the St. Croix address. I moved there since 2013.
Okay.
St. Croix.
It's on Immokalee Road. It's a complex off of Immokalee Road. I want to say it's 45, but now I'm looking at this and I might have mixed it up with this address. I want to say it's 40 something. I don't have anything. I could look on my computer for the address.
Go ahead. What was the address that you were in December of 2016 when the service was purportedly effective?
First. I tried Googling. Can you hear me?
I can hear you.
I tried Googling Yolanda and I couldn't find her recently, and the
You don't have the
property addresses. No, the property address wouldn't come up. Trying to find St. Croix. Oh, I'm trying to find the St. Croix. Well, am I looking for the address in 2016 or am I looking for the St. Croix address? I don't know, which one do you guys want?
Well, I would be interested in your address in 2016.
Right.
It's with Yolanda and on Immokalee Road. Yolanda Oscar on Immokalee Road.
Well, I'm very familiar with that general area of town. Where on Immokalee Road specifically?
It's behind the fairgrounds are here. There used to be, and I think it's changed a little bit now, when you go past it used to be the country store, you go past it a little, and there's a median, and you'd have to turn right after the median. There was not really a turn to go in there, and it was in the roads behind there.
The name of the road was St. Croix?
No, that was in 2016. 2015 to 2016, I was living with Yolanda,
Right.
and I was coming back and forth.
Where was Yolanda living?
On Immokalee Road. She lives off of Immokalee Road.
Well, there's nothing that's on Immokalee Road directly. I mean,
No, the fairgrounds are to the right.
Yep.
There, when you pass,
I know where the fairgrounds are.
this is Immokalee Road. What's this? DeSoto? What's the one that runs right in front of Palmetto High School and the Horseshoe Elementary?
What's that?
Oil Well. When you pass Oil Well Road, there's a median right directly after the light. At that median, you have to take a quick left, and she lived in the houses behind there.
Well, what's Yolanda's last name?
Oscar.
Yolanda Oscar.
Yes, the last time I spoke to her, she was going through a divorce, and she was thinking of leaving, and I haven't been able to get in touch with her. But I looked her up on the property appraiser, and I looked her up on the
Did you have
Google.
You say you lived there for a few years. Do you have any sort of?
No, 15 to 16. No, I don't have anything that I had received there. I didn't have cable. I didn't have anything in my name there.
All right.
But what was your driver's license at in 2016?
My driver's license has always been the 3980 address. I was supposed to change it last year, part of our divorce agreement when my son turned 18 2 years ago, 19, but then the pandemic hit in April of last year and I wasn't able to change it. So I have not changed it.
All right.
But I have lived in Miami now for 5 years now, almost.
5 years. So,
Like here, permanently, 4 addresses since 2017. When I was coming back and forth, it was 2016.
Well, you said you moved there in 2017. That would be
2 states.
4 years.
Right. It's according to my math, but I've never been good at math.
4 years. Okay, 4 years. Yes.
Yeah, I'm not. Yeah,
Well, coming back and forth was in 2016, and that didn't last long because in February of 2017 I lost that job, and then I kept looking for work, and I found the next job in.
All right. Well, at this point, given the testimony I've heard, I do find that the plaintiff is at least, has certainly established a prima facie case, given that Soto's license still had that address, her son was still registered for school at that address, that there's a prima facie showing that that was valid service of process. Plus, there is the return of service that's part of the court file at this time. So, ma'am, so what that means is it just shifts the burden now to you, since it's your motion. So you just have to establish by clear and convincing evidence that you, in fact, were not residing at that address at that time. So, you said you had other things you like to provide. Mr. Haynes, I didn't mean to just cut you off, but I think that, you met your threshold burden at this point. And so, Ms. Soto, you can still establish through whatever you want to present at this time that you, in fact, were not staying there at the time of service.
Well, in the exhibit that I submitted, Exhibit D, it's a letter from November of 2013 from my ex-husband that were separated at the time already. Oh, Exhibit A, I'm sorry. Exhibit D is the termination letter.
Sure. Let's see. And Mr. Haynes, I'll pull this up so you can see it as well. Here we go. There we go. All right, yes, ma'am, go ahead.
So in November of 2013, I had already left the residence. I was trying to figure out insurance for my son. I didn't qualify I couldn't pay his blue. Anyways, long story short, my ex-husband writes this letter to Medicaid so that my son can qualify for Medicaid, saying exactly what I'm telling you, that in 2013, I no longer lived with him. We were already going in the transition of figuring out custody and support and things along those lines. Between us, we had figured out that, he wouldn't give me money direct anyway, it's not part of the case. But it shows that I did not live at that residence since 2013. And I understand what you're saying about not changing the addresses, but not changing the addresses wasn't in a way to avoid service, which was what happened, what happened then, that they served that address. It was for my son's stability. And part of our agreement had been that he would go after school, weekends, every other weekend. But by the time he moved in his girlfriend, my son, there was a conflict, and my son wasn't there the way that we had agreed he would be there, the way the divorce agreement had agreed he would be there. I definitely didn't live there in 2016 if my ex-husband moved in his now girlfriend and their family in 2016. So I certainly didn't live there in 2016. I apologize that, yes, my life was a little bit unstable because in 2015, I left a job that I had for 15 years and I couldn't find work in Naples. It's like all of a sudden I had a black cloud over me and I was going back and forth trying to be there for my son, trying to make a living off of my savings, living in my friend's, she had converted her living room into like an efficiency for her parents. Then her dad died and she let me stay there. And I'm sorry that I don't have the address for that, but I knew that there was a transition that was going to happen, and it happened sooner than I expected it to happen. But I lived with my friend Yolanda. I was coming to Miami to look for work, and I did not live at that address since 2013. I just did not. And in 2015, when I lost my job, I obviously lost where to live, that I had to pay $1,500 of rent all by myself. So I went to live with my friend Yolanda. I don't have proof of that part, but I know that in November of 2016, I was coming to Miami to work 3 times a week at the very least. And then I lost that job in February of 2017. So my address, and the thing is, I wasn't trying to avoid service. If the plaintiffs had talked to a neighbor, because there's a case filed in 2018 and the docket entry, well, anyways, it was a small claims case filed. When I'm researching this case, I find a 2018 case. The return on non-service, it states on 3/6/2018, per Sixto Soto, ex-spouse, subject resides in Homestead, Florida. So if they had spoken to an adult in that house, they would have known that I didn't live there. The only thing I can imagine is they asked somebody, is your mom home, or is Minerva Soto home? Somebody said no. They handed somebody the papers. Those papers never made it to me. I would have done exactly what I did when I got served with the writ of garnishment of my current place of employment. I called to acknowledge it and try to understand where I was. My former neighbors across the street who have been there for years, if someone had gone to them, and I saw somewhere, I don't know if it's in the 2018 case or this case, but I think in this case they made 2 attempts. They saw different cars in the driveway. I don't know if no one answered, or they had options. The plaintiff had other remedies. If I was trying to avoid service, they had other remedies available to them to try to serve me. They could have spoken to neighbors. And then we already said that it's well settled that for purposes of the statute 48.031, that a person can only have one usual place of abode. The fact that my license didn't change was for the stability of my son. It wasn't to try to defraud anyone, my creditors, anyone, because, that's why I submitted the counseling thing.
Your reason for being there or not is not really an issue. Whether you were there or not.
I was not.
That's really the issue. All right, Mr. Haynes.
Well, Your Honor, I mean, I can understand Ms. Soto was having a difficult time at that particular time, but I mean, it looks like there was, at least from all like official records, that she has as evidence, her usual place of abode was at this address in Naples. I think it's 3980 31st Avenue. She had the driver's license, remained, at that address. Also, as for school purposes, as she has admitted, she maintained that address with her ex-husband. And I understand it might have been for school purposes, but for, purposes of, there's no real knowledge of that her actual address at the time of this substitute service onto her son.
Well, actually, Your Honor, the plaintiff did get that address. They do have that address, the 14500 that's on my W-2 in 2016, because that's the same address that they filed a second notice of intent. They sent it to that address in March of 20.
That place wasn't your usual place of abode either, is what you're telling me, that you weren't residing there.
Right, I didn't receive it, but in March of 2021, they had access to that address. So plaintiff has greater access to databases that would be able to find me, which they did. If they have the address, it doesn't mean that they only got it in 2021.
The issue today is whether or not you were in fact residing. Have you shown by clear and convincing evidence that you were in fact not residing at the 3980 31st Avenue Northeast address on December 16th of 2016? That's the only issue for me to address today. And I've got conflicting evidence. Plaintiff's counsel makes a pretty good point that you tell me your driver's license had that address, your son was registered for school at that address, but I've got you telling me that you weren't there. And that, you were divorced, that, your husband had sent this letter to, you said, was it Social Security at the time?
No, Medicaid, Access Central.
And in the letter, it does say, before Minerva moved out of our home. And this letter is purported to be dated back to 2013. And it says, Aaron gets dropped off at my house every day after school, since he stayed enrolled in the same school, which is closer to my house. I drop him off to his mom so she can take him to school in the morning, and 2 days a week and spends the night, and I take him to school. So, like I said, I've got really conflicting evidence on this issue. So Ms. James, are you arguing to me that I should not believe Ms. Soto's testimony that she was not residing at the house? I said, because the cases are quite specific in their definition of usual place. It must be the place where this person is living. And she's saying she's not. Should I disbelieve her?
Well, Your Honor, her testimony is stating there was some confusion as to her actual place of residence. Okay, because in most cases, there is at least some type of evidentiary support. There was maybe if there was an affidavit from the Yolanda Oscar, stating that she was living at the Immokalee address, then that, I guess, could weigh more in the favor that she wasn't living at the 3980, or that the son wasn't at least living there. Okay, and so that's why this is a little confusion as to the actual evidence of address. Then even on the W-2 that was submitted for 2016, that's at an address in Homestead. Mm-hmm. So it appears that Ms. Soto is kind of using the address as that kind of at the convenience,
right?
Yeah. So it's hard to understand the exact location of the address, but from the official records, the address is at 3980.
Well, Your Honor, there's a case that was filed, that I filed in 2015 against my former landlord at the St. Croix address that is public record, that shows that I lived there since 2013, and I was suing her for the return of my deposits because she refused to return them. And I filed that case in 2015.
You have that case number?
I do not.
And that here in Collier County?
Yes, it was filed in Collier County.
Give me a moment.
And that's the St. Croix address that I was trying to find for you earlier.
Let me pull that up.
Can I get a drink of water, please?
Sure.
It's right behind me.
Sure, but I still need that case number. Yeah. Ma'am, is this case number 15 SC 1409?
Oh, I didn't.
Mr. Haynes, do you have that?
It's versus Linda. It was against Linda McGrath.
Yep.
McGrath, I think was her name.
Yep, 15 SC 1409. Mr. Haynes, do you object to the court taking judicial notice of the contents of that case?
I'm just, I was going to attempt to pull it up myself here.
Yes, sir. So I'm looking at the complaint and I find well, I'll let you take a look if you can pull it up, Mr. Haynes.
Did I have a case number?
Yes, sir. Give me one moment here. That was 15 SC 1409. All right.
Okay.
You agree that I can take judicial notice of the court file in that case?
Yes, Your Honor.
All right, Ms. Soto,
Yes,
I'm looking at the complaint in that case.
yes.
And in it, I'll show you what I'm looking at.
Mm-hmm. I did.
Give me a moment. You see what I'm looking at?
I do. I have it up on my computer.
I'm looking at number 5. On or about April 10th, 2015, Ms. McGrath and Ms. Soto had a telephone conversation at which time Minerva advised Ms. McGrath she would not be renewing the lease because as part of a supplemental divorce proceeding, she had negotiated taking possession of the marital home.
Right. And that fell apart.
Well,
Because right after that, on the 22nd, I was going to stay again. And the 24th, I was like, yes, I'll pay extra because I had to live there because it fell apart.
well, ma'am, I've got a copy of the, where is it? Here's the order from
Oh,
the judge in
yes.
2015. And here is a stipulation.
Yes.
And it says, ex-husband agrees that Minerva and the party's minor child will move into the marital residence located
Yes.
at 980 31st Avenue Northeast.
Correct. And if you look at the same case in 2014, it was the same exact agreement. He never relinquished possession of that house, ever. Every time that we would have these conversations, he would take it back and he would not move out and he would make our lives impossible. So in 2014, we came to the same exact agreement. I forwent alimony. I reduced the child support just so that my son and I could live in that house so my son could finish school in that house. And he never relinquished possession of that house, ever. I wasn't allowed to, if I was gonna move in, I wasn't allowed to change the locks. He had to come by whenever he wanted. He wanted to inspect the house every single day. It was a nightmare and it never came to fruition because we had the same exact agreement in 2014 and I renewed the lease in 2014. And in 2015, he left me the same way, one hand in front, one hand in back, trying to scramble, figure out what I was gonna do because now I ruined the relationship with the lady I had where I was living and I had to scramble to find somewhere else to live. He did the same exact thing to me in 2014.
All right.
But I had more time then to be able to renew the lease.
So ma'am, I gotta tell you, at this point, because the burden is on you to show by clear and convincing evidence that you were not residing there at the time. And now I've got court files indicating that you had, by court order, retained possession of that house in 2015.
I understand.
I find that you have not met your burden. All right.
Okay.
And so the motion to quash service is denied. Now, all that does at this point, ma'am, is the pretrial remains as set. All right.
I have evidence from my boyfriend that I still live with now, that I did live with him in December of 2016, that I was coming back and forth to Miami in December of 2016.
How you're living with you?
Well, I didn't live with him. I was down here, back and forth, that he knows that I was coming to Miami. He lives in Miami. We live together now. And that he can testify that I was coming back and forth in 2016.
But ma'am, today,
in December of 2016.
Ma'am, today is the day for the evidentiary hearing.
All right.
And it's your burden to show by clear and convincing evidence that this process was not properly effected. What I've got in front of me today is your testimony versus your, you told me your driver's license address was that, your son was ready to go to school there. There's a court order awarding you custody of that home, the year prior. All of the record evidence that I have contradicts what you're saying.
Well, Your Honor, I don't know that it does contradict.
I'm not saying I don't believe you. I'm just saying you haven't established by clear and convincing evidence that you were not residing.
But I couldn't have possession of that home and be working in Miami. Because if I had possession of that home, I wouldn't be paying rent and I wouldn't have to be looking for work. I could have lived off my savings and not have moved because I wasn't supposed to be paying mortgage if I lived in that house. That was all part of the 2014 agreement that never came to fruition.
Wow.
So I was working in Miami, so that doesn't prove that I needed to work to find employment because I was not living in that house. And I had to find a way to support my son and myself. I did not live in that house in 2016. My ex-husband moved in his girlfriend that he lives with there now to this day, and they have a child together since 2016.
I understand. However,
I have bank records that I could pull up that I have redacted.
Hold on a moment.
That shows.
Hold on a moment. Oh, okay. No, go ahead. You were saying?
I have bank records from August of 2016 that show that I was actively coming to Miami to look for employment. That I was coming down here.
I believe you were, man. That you may have been working there. You may, that you were, in the middle of this divorce situation, which is, often messy for people. I understand that. But like I said, I have to make a ruling based upon the evidence before the court today, and the burden is on you. And if you look at the case law, it actually, describes it as a heavy burden to show by clear and convincing evidence that the service of process is not properly affected. And I said, and given the record evidence that I have before me, I find you have not met that burden. So, so I'm denying the motion to quash service. That doesn't mean the final judgment goes back into effect. I know,
but I just
the setting aside
trying to be able to present everything that I possibly can. The plaintiffs did have the 14500 address, Your Honor. I don't know how long they had it.
At the time, ma'am. That wasn't your address at the time. You told me that wasn't your address at the time, so it wouldn't have made a difference.
It was an address at the time. It was an address that I was using that I submitted as an exhibit.
Right, but you're telling me you didn't.
It was an address that I was at 3 times a week at the very least.
Ma'am, you told me you didn't live there. That was not your place, you were using it. So that's also not your place of abode.
I was living in 2 places. I had the efficiency and I had this address that I lived down here. So I was sleeping here overnights 3 times a week, living there 3 times a week. So it was, give and take. That's why that employment didn't last as long as it could have, or it should have, or I could have. If I would have been down here permanently, I would have been able to report to an office every single day. But I had a minor son that I had to take care of.
Man, I'm not faulting you. I'm just saying evidence is before me. That's all I'm saying.
But the evidence doesn't show that I lived at 3980. The evidence that I lived at 3980 is also conflicted by the evidence that I presented to you today, Your Honor, because 3980 doesn't make 3980 my address.
Ma'am, I've made my determination. That
okay.
Given what I've got before me, you have not met your burden to prove by clear and convincing evidence that the service of process was not affected. And so the pretrial remains the set. You're still free to defend at this point because the final judgment has been set aside. There's a pretrial and a mediation set. If you cannot work out an agreement with the opposing party at that time, it'll be set for a final hearing, and you can still defend on that issue, on any issue you wish to raise. The case is very much active, and you're still free to defend. But at this point, service is denied. Okay. Let's see. The pretrial is currently set. Did I put that in the original, the previous order? Except for May 14th at 10:30.
May 14th was May 9th.
I don't know if the notice has been sent yet. I'll make sure that it gets sent out. If there hasn't been a proper notice sent out yet on that. All right. and I'll do an order with regards to my determination of case proceedings. Okay?
Thank you.
Thank you. Thank you, Your Honor.
Thank you both. I'll get an order to you. All right, Madam Clerk?